welcome to our webcast, Avoiding Nuclear Meltdown, How Insurance Counsel Are Working to Constrain Generous Juries. I'm John Weber with AM Best. Headline verdict amounts continue to rise, dragging up settlement values and turning claim scenarios into high-stakes negotiations. A panel of insurance defense experts that we've assembled here today will explain how new research and strategies are helping insurers to better assess, triage, and limit their litigation liabilities, and how to counter an increasingly better funded, coordinated, and sophisticated plaintiffs' bar. We'll meet that panel in just a moment. Now, we may mention the subject of financial strength ratings. A full explanation of AM Best ratings is available online at ambest.com/terms. The opinions expressed by our panelists are theirs and theirs alone and do not necessarily reflect the opinion of AM Best. Today's presentation is being sponsored by Best Insurance Professional Resources, where you can find client-recommended attorneys, adjusters, and expert service providers to meet your needs and searchable, comprehensive online profiles. AM Best is proud to be a premier sponsor of DRI's 2022 Insurance Coverage and Claims Institute Seminar. And now let's meet our panel. First, we welcome in today Marie Castronuovo, partner with Russo and Gould LLP. Marie,
Hi,
so
John.
glad you could join us today.
Thank you, John. Nice to see you.
Next, we say hello to Dr. Steve Wood, litigation consultant, Courtroom Sciences Incorporated. Steve,
Hey,
welcome.
John. Hey, John. Glad to be here. Thanks.
Next, we say hello to Alan Russo, a partner with Russo and Gould LLP. Glad you could join us today, Alan.
Thank you for inviting me. It's an interesting topic.
And last but not least, we have Dr. Alyssa Parker, litigation consultant, Courtroom Sciences Incorporated. Alyssa, so glad you're here.
Thanks, John. It's a pleasure to be here.
And Alyssa, we're going to start with you today. What is the definition of a nuclear verdict?
So a nuclear verdict refers to unexpectedly high damage awards that exceed rational parameters in civil litigation. Some people argue that it's damages that would exceed 10 million. Other people say that it's just a significant deviation from what would be expected in a case. But at the end of the day, a nuclear verdict is just in the eye of the beholder. So a small company that gets hit with a $2 to $3 million verdict would have a similar impact as a large corporation that gets hit with, say, a $50 million impact.
Interesting. Marie, are you seeing trends when it comes to regarding damage awards?
Absolutely, John. All across the country, we're seeing trends of awards rising higher than they've ever been before, especially in New York. What we're seeing, it kind of looks like punitive damages instead of tort damages. So, and I'm speaking strictly of personal injury. Personal injury damages are supposed to redress the plaintiff and give plaintiff reasonable reparations for injury sustained. Pain and suffering is usually is a very subjective thing. So those awards are really susceptible to nuclear verdicts and social inflation. Plaintiffs' attorneys have done a very good job in increasing these awards by using these themes of us against them and bad corporations being bad citizens, and they're raising the emotional ire and they're fueling emotional fire with not only their plaintiffs but the juries also. The CPLR allows plaintiffs' attorneys in their summation to actually suggest a recommended amount of money to award for pain and suffering. And that if the award is excessive or inadequate, it will be reduced by the appellate division, but the appellate division only reduces it in terms of what they think is materially reasonable. So frequently, even with those reductions, we're still looking at awards that are in the stratosphere.
You mentioned social inflation, and we want to talk about that in just a little bit. But before we do, Alan, would you have any examples of these nuclear verdicts?
Well, yeah, I mean, I did a sort of an overview across the country. Now, our firm is in New York. We mainly deal with New York cases, but I did a brief overview, and what was kind of stunning to me was the explosion over the last 6 or 7 years. To give you an example, back in 2016, the top 50 verdicts in the country range between 2.6 billion and 40 million. And about 2/3 of those cases were personal injury cases. Some of the higher verdicts actually were for commercial cases or IP cases, patent infringements or IP cases. And then in 2017, the highest verdict was $4.1 billion. So it's doubled in 1 year, with the low end being around 25 million. Then in 2018, the highest verdict was 4.7 billion, and now the 50th highest verdict was $50 million. In 2019, there was an $8 billion verdict in a medical malpractice case out in Pennsylvania, $8.6 billion. And the 50th highest verdict in 2019 was $54 million. And 2020, it was a $9 billion verdict. And the lowest verdict in the top 50 was $9 million. Now, the numbers from 2020 and 2021 still sort of being accumulated, are harder to measure because there have not been nearly as many jury trials across the country, especially in New York. Very few jury cases went to trial in 2020. There were some, but not many. So it's kind of hard to gauge right now in light of the pandemic, but we're definitely seeing, across the board, kind of an explosion. And I'll just end this by the most stark example I saw was from 2011 to 2019, trucking accidents. 2006 to 2011, there were 26 cases where there were verdicts over $1 million. From 2011 to 2019, nearly 300 cases. That averages 50% inflation rate from year to year. There's definitely something going on, and it's definitely manifesting itself with an incredible explosion in jury verdict exposure.
So let's find out what's going on. Steve, you just heard what Alan had to say, and he says he's shocked by the explosion of these verdicts. What does your research show are the causes of nuclear verdicts?
Well, the causes of nuclear verdicts, there's really 5 that we've kind of pinpointed. The first one being problematic witnesses. So we do a lot of work with witnesses across the country to make sure that they present credibly in both deposition and at trial testimony. The problem is a lot of times witnesses don't have that training and aren't prepared to go in and, combat against these tactics that the plaintiff bar is using. So they'll go in and make psychological errors. And what I mean by that is they'll have cognitive breakdowns. So they'll answer too quick, or they'll misunderstand the question, or they'll adopt language that the plaintiff attorney wants them to adopt that's harmful to the case, or that plaintiff counsel is using for very specific reasons to try to get you to adopt to their themes. Witnesses just aren't catching on to that, and then they go forward with it. The other thing I'm talking about is, really emotional meltdowns. That would be, you get into a situation where you're flustered, you're upset, you're confused. All of those things then leads you to give bad testimony as well. And then finally, we have these behavioral, it's the whole adage of it's not what you say, it's how you say it. Witnesses are making very bad behavioral movements, rolling their eyes, slouching in their chairs, looking at their attorneys, all these things that they're doing to call into question their credibility, in front of jurors. And really similar on the lines, I'm sure many of the people who are on this panel, and definitely those people who will be watching this webinar, are familiar with the reptile theory and reptile theory tactics. And what happens really is witnesses just aren't prepared to be able to answer the tough questions about safety is your top priority, or you should do anything to avoid unnecessary risk or needlessly endangering individuals. They don't know how to answer that correctly, so they step in it and cause bad testimony. So that's the first one. Second one is egregious conduct. That's where, you hear a lot about these companies who have done things where they're insensitive, or they haven't handled things properly on the front end, or they haven't handled things properly on the back end. I think to the McDonald's case being one of the most prominent ones that sticks out in everybody's mind. And when you look, McDonald's had 700 complaints prior to the incident that led to the litigation about the coffee being hot and McDonald's didn't make any adjustments. Or the idea that they found that hotter coffee increases the smell of coffee, and the increase the smell of coffee sells more coffee, right? So now you're in that profits over safety type thing where you're doing things to increase your sales number, but putting people at risk. So those are things that are going to inflame jurors because they see how careless and hapless and reckless that these companies are. Third thing, punitive jurors. And that goes back to what Marie was saying earlier about now she's kind of seeing this difference from not just compensatory, but more punitive. There's jurors now that, don't necessarily want to just compensate the plaintiff for what they've lost, but they want to also punish the corporation. And even though punitives might not be on the table, that line gets blurred between compensatory and punitive, and that, your punitive actually bleeds over into your compensatory because, like you said, they want to give the verdict so high that it stings and draws attention and basically causes that large corporation to pay attention. Fourth, not my term, but judicial hellholes. More American Tort Reform Foundation uses that as really a term to identify those kind of plaintiff-friendly venues. I know you guys in New York are in one of those judicial hellholes.
Absolutely.
Yeah, Cook County in Illinois. So you have those where, when you're trying cases there, you have either jurors who are very pro-plaintiff or you have judges who are very pro-plaintiff. And when that happens, obviously, right, rulings get done and made in favor of the plaintiff, which puts the defense bar behind the 8 ball at the bat because they don't have the ability to argue the case the way that they believe they should. And then finally, and I'm sure we'll talk about it a lot on this, is plaintiff attorneys are just, their tactics are just a lot more aggressive. They're a lot more creative. They're a lot more willing to do things in the courtroom, willing to do things in depositions that defense attorneys just aren't willing to do. And it's not necessarily because of, anything related to that. It's just more or less not how the defense bar operates. The plaintiff bar just operates a little bit differently and does things, like I said, that are a little bit more aggressive, that help them to be more successive, that, like I said, the defense bar just doesn't do. So those would be really the 5 things that we've seen that have been kind of the drivers of these nuclear verdicts.
Let's take it a little bit deeper, Steve. What are some under-researched causes of nuclear verdicts?
Yeah, so one of the things that we hear often is millennial jurors. A lot of times it's these millennial jurors, they're the reason for the nuclear verdicts. And what we've actually found in our research is that there's not really a significant difference between millennial jurors and other jurors in their damage awards. Sure, some millennial jurors might give high damage awards, but Alyssa and I do research all over the country and work with jurors on a weekly basis, and we'll see jurors who are in their 50s and 60s giving verdicts just as high as millennial jurors. So these are some things that need to be researched, and I also want to preface and say these very well could be found later, but at this time right now there's just not enough information or not enough data to show that millennial jurors are really problematic. I think the other thing, really, another one that comes up is this concept of the devolving concept of money, right? We see our athletes are making $250 million for their contracts, or, some guys are making $20 million a year, and it's leading people to kind of not value a dollar like they used to. Once again, in our research, we're not seeing people doing that. I haven't really ever heard jurors talk about anything related to contracts or, Patrick Mahomes makes X amount of money in a year, so this guy needs to make as much. I'm just not seeing that concept of, dollars don't count as much as they used to as something that's driving up nuclear verdicts. And then finally, I'll say that one of the other things we've seen too is this, breakdown of institutional trust, or the media, this fake news and all the other things that are going on right now. I mean, if you look back across the ages, people have always been kind of angry. People have always been mistrustful of the government. People have always had things that they viewed as problems in this country. And I don't think we've seen anything really where people's perceptions have shifted so far, one way or the other, that it's leading them to give nuclear verdicts. So like I said, I think, and I would even say third-party litigation financing, which I know someone's probably going to, mention here on this as well. I just haven't seen it yet as far as leading to nuclear verdicts. With that said, I'll couch it in the fact that third-party litigation is allowing plaintiff attorneys to be able to take cases to trial and do things that they wouldn't normally do. But if you circle back to the causes that I was talking about, if you have the training, if you notify and identify those areas that I talked about in the 5 causes, you can help tamper some of that, even though that this litigation financing is being thrown at plaintiff's way.
Thanks, Steve. Marie, you just heard what Steve had to say. He doesn't think third-party litigation financing is having an impact on nuclear verdicts. Do you go along with that?
You know what? I disagree, John, and I'm going to tell you why. But before I get into that, I just want to make one comment on something Steve did say. He talked about the idea of inflation and people devaluing the dollar. You know, at the end of the day, he's right. And at the end of the day, we're talking about the same thing, whether it's 2019, 2021, or 2020 or 2000. It's a pain and suffering award. People's pain is the same now as it's been then. It's not any more intense or it's not any more unbearable. So why are these awards going so high? Why are they getting so out of control? So the devaluing of the dollar, I think, is big. But there's so many other things I think that come into play, litigation funding being one of them. I know he disagrees with me, but let's talk about this. Litigation funding over the past 10 years has exploded. It's a huge market in this country. It's been a huge market overseas for years. The UK, Australia, they've been dealing with it forever, right? For a very long time. It's come to us now. It's been here for a while. It's getting more and more popular. If you look on the internet, you see advertisements for these companies. If you go, I was on LinkedIn the other day. And an attorney I know, plaintiff's attorney I know, posted boasting about a settlement that he got, a great settlement, very large number for what I think sounded like, not an injury that deserved it. But he was boasting about this number. And right underneath his post was a comment from a funding company advertising, telling him, well, if you've got other cases like this, you can send your client to us. We'll help them, with the litigation. We provide great rates, blah, blah, blah. I had a laugh. I'm like, what are they doing? There's nobody regulating this industry. It's like the Wild West out here. These guys, they're third-party funders. A lot of these funding companies are funded by hedge funds and venture capitalists and basically gambling. They're gambling with money that they know how to gamble with. These are people who are in the industry of investing. So they know how to invest their money. They're very, very smart investors. They're looking for cases to just fund away. They're not, when they're getting these cases, they're not talking a lot of times to the plaintiff's attorney to find out what the value of the case is. They're just loaning money. Why are they loaning money? Because they're getting some poor schmuck to sign on for this money and agree to give them 35%, 40%. I heard of one company charging 50% interest on their loans. I had a case last year. We tried to settle. We'd been in front of the judge several times. A certain number was bandied about, was thrown about. The judge recommended it. Plaintiff's attorney said, my client accepts it. He'll accept it if they offer it. I couldn't get the money. After about 6 months, I got the money. I made the offer. He accepted the offer. I sent him the closing papers. Months later, I didn't hear from him. Finally, I got in touch with him and he said, well, my client won't sign it. Why won't he sign it? He's got a funding loan. He took out $10,000. Now he owes $80,000, and he can't reconcile that difference. So we had a big problem with this case. So, and those are minor dollars. But in terms of driving up the nuclear verdicts, what happens is a lot of times these plaintiffs' attorneys don't even realize that their clients have taken out these loans. And when they find that out, they realize they've got to build this case up because there's no way they can settle it. And if they end up in front of a jury, they may get a nuclear verdict, they may not, but they've got to, in order to do that, they've got to hedge their bets and really build this case up so that they can get the money that they need to resolve it, even in settlement. So insurers are having a hard time settling cases at mediation. They're spending more time on mediation, spending more money, mediating and negotiating the cases. When we're talking large dollars, we all know the structured settlement has been a very popular vehicle to resolve a lot of these cases. Can't do that when there's a loan like this that you've got to pay up front. So that kind of puts to bed the idea of structured settlements. So at the end of the day, these funding companies are they're not helping; they're injuring both plaintiffs and their clients, and making it very difficult to resolve cases that would otherwise be easier to handle. Now, I'm not going to mention any names, but within the last year in New York State, New York City in particular, we had a case. There's federal charges pending against a plaintiff's attorney, two plaintiff's attorneys, two doctors, two treating doctors, and a funding company for I think the charge was email fraud or wire fraud or something like that. But what it comes down to is they are actually trolling the AA sites and the NA sites and homeless shelters and finding people who are willing to say, yeah, I fell here. And then the funding companies is funding that kind of litigation. And they've got doctors on their payroll who either send clients to them or agree to do surgery on these people who really don't need surgery, just to drive up the costs and the expense of that case and to drive up the value of that case. So I know you're going to say, well, this is atypical, and it may be, but it may be evidence of a wider disease that the litigation companies are really feeding off of. So we really need to do something about regulating them. I hear that there is a bill presently in the New York Assembly and Senate to deal with regulating at least the rates that these companies are charging. But right now, like I said, it's like the Wild West. Anything goes.
I believe that there is regulation in New Jersey, first in the nation regulation, requiring disclosure if there is third-party funding for cases. Is that correct?
In New Jersey, yes. In New Jersey, I don't know the extent of it, but it may only be dealing with the rates that they're allowed to charge, but nothing more. I mean, these companies should be held to the fire. They're giving money out without knowing what they're giving money to, and then they're not caring. So it should be that the plaintiff's attorney should get involved. The plaintiff's attorney should be on the hook for how much is being loaned and what the rate is.
So Marie, you mentioned social inflation earlier. Has that impacted settlements?
Oh, sure, it sure has, just as Steve was mentioning. So there are a lot of factors involved in social inflation, but I think for most people, the very first introduction is, as he said, I just read the other day, Tom Brady is retiring from football after 22 years with a total earnings of $292 million. And this is typical across not only the professional sports leagues, but entertainment. I mean, people are hearing about all these crazy numbers that other people are making, and they're thinking, well, why not me? Where's my money? What am I doing? I'm not earning that kind of money. The mortgage rates, real estate rates, houses, the prices have gone up. People are paying more at the grocery store, especially since COVID. Things are all rising in prices. People are starting to get irate. They're starting to get to even more so distrust large corporations, and because these corporations in their minds are behind all of this inflation. And this is all coming out in the courtroom. Plaintiffs who are bringing lawsuits have higher expectations than normal. And it's very difficult, as I say, to settle a case that's been affected in this manner. And plaintiff's attorney, if he's got a client that wants that kind of money, he builds them up, and he's got to. At the end of the day, he's got to show me the money. He's got to get the money. He's got to somehow build the case up so that either the jury or the insurance company is gonna pay that kind of money. But so what do? They use different themes, the good guy, bad guy, us against them. I mean, you see it even in advertisement. There's one national firm, that portrays themselves as the good guy, and they're going to fight for you. And it's this and reptile theory thing that says, well, we're going to put you, in the plaintiff's position. If this happened to you, how would you feel? These big corporations are bad corporate citizens, and they're breaking all these rules, and they're not paying attention to safety, and we've got to punish them essentially for that. So when that is sold to a jury, that's exactly what happens. The jury feels like, okay, we've got to award this person not just for the pain and suffering. The number rises exponentially because we're also punishing the defendant.
Thanks, Marie. Alyssa, what are your thoughts on this? Why are settlement amounts continuously increasing?
Well, I think what is clear from our conversation so far is that there are a lot of different factors at play here. What we have seen, especially with regard to nuclear settlements, they've been the result of weak ineffective, or just plain bad witness deposition testimony. So when you have bad witnesses, you lose leverage. And the plaintiff's bar knows this. So they are going into depositions with the sole focus of destroying defense witnesses. When this happens, they're in the driver's seat at any type of settlement, negotiations, mediations, and so on. They are willing to take this to trial, and the defense can't risk that, especially with this bad testimony. So they are in complete control and can dictate what these negotiations look like. When it comes to nuclear verdicts at trial, once again, witness testimony plays a key role. Going along to what Steve was saying earlier, oftentimes these witnesses are not properly prepared. And what do I mean by that? Can they withstand that aggressive and relentless questioning? Can they withstand reptile tactics? Have you addressed the emotional component? Are those nonverbal behavioral aspects that are so incredibly important, have they been addressed such that this witness is prepared to go through both direct and cross-examination and so on? And the last part is something that was discussed at the very beginning of today, and that's the idea that at the end of the day, the plaintiff's bar is out communicating and out preparing the defense bar. Again, as Steve mentioned, the plaintiff's bar is willing to take on some of these unorthodox, aggressive tactics in areas in which the defense tends to be a little bit more conservative and risk aversive. In addition to that, they are doing a ton of pretrial research. So they often know the holes and the weaknesses in their cases and the strengths of their cases from a juror perspective, which of course is driving how they're working up the case and their willingness to go to trial in the end.
Interesting. Alan, are appellate courts doing anything to help rein in nuclear verdicts?
Well, they used to. They don't do much anymore. You know, the appellate courts have changed. The appellate courts used to be like the bulwark against crazy jury verdicts. And I've just, anecdotally have seen a sea change in the appellate division, at least in New York. And for example, there was a case I was looking at yesterday where I was reviewing jury verdicts and the sustainability of a herniated disc with a fusion in the neck. And it was a verdict of $3 million for pain and suffering only. No special damages, $3 million in pain and suffering. And the trial court reduced it to $500,000. Wow. The appellate division reversed the trial court reduction and increased it, reinstated the $3 million pain and suffering award. It was shocking. Never saw anything like that before. And then we have these two recent cases in New York. And it's really, as I said, astounding to me. It shows how far the salesmanship of the value of personal injury cases has made its way into the highest levels of our courts, where we had a case that was a bad incident. Someone fell at a concert and fractured his skull. He had multiple injuries, life care plan. It was a bad case. There's no question about it. Verdict was for over, I think, $90 million. A large chunk of that was for special damages, economic damages, which were reduced, but were still allowed. And the pain and suffering award was, I believe, $59 million or something close to that, and it was reduced by the first department, which is the department, probably the most influential department, appellate division in New York, to $20 million. Pain and suffering, 12 million. I think it was. Let me get the exact numbers here. I think it was 12 million past, or no, excuse me, 7 million past and 12 million future. $20 million in pain and suffering, sustained by the appellate division. That was almost double the last highest sustained verdict for pain and suffering in New York, which was only a few years ago. And then, astonishingly, the end of this year, and that came down in April of 2021. In December of 2021, there was another really horrible case involving a student who suffered third-degree burns over 35% of his body as a result of an experiment in school that went awry. Terrible case. The verdict, I believe, was, let me see, the total verdict, that was the Yanes case. The original verdict on that case was $60 million. Large sum of money. Most of that was for pain and suffering. It was reduced by the appellate division to $29 million in pain and suffering. So the same court heard two horrific cases and 6 months later sustained pain and suffering award that was almost 50% higher than 6 months earlier. So I believe the sort of acceptability of these outrageous jury awards has kind of crept into the consciousness of the appellate judges as well. And, it does not portend well in the future.
So then, Alan, how can the insurer defendants minimize the potential for a nuclear verdict at trial?
Well, look, a lot of, both Steve and Alyssa touched on this issue already. And I, as someone who tries a lot of cases and see the dynamic every day as to how jurors react to testimony, how they react to, plaintiff's attorney's tactics. Everyone probably is aware of the whole reptile theory and the tactics deployed these days. The most important thing is you got to start from the beginning of the case. You got to know what you're dealing with. If you sense that there's a case that can go, in a bad direction, bad injuries, circumstances are not good for you in terms of, liability defenses, you got to from the outset. You got to start, you have to anticipate, kind of reptile tactics, and you got to fight them. You got to fight them at depositions. You got to call them out on it. You got to make motions before the judge who's handling the case. If the discovery is going beyond where it should go, if the discovery is going into territory that has nothing to do with the accident itself, but really about trying to paint a bad picture of your client, you got to fight them on it. And you got to serve notice early on in litigation. You're not going to put up with it. And you also need to school the judge who has the case so that they're sensitized to this being deployed in this case. And you're letting the judge know that you're taking this up on appeal. You're not putting up with it. And it does have a salutary effect, because once the judge hears enough of it, they get fed up and they start to rein in the plaintiff's lawyer. So that's the first thing. Secondly, in terms of witnesses, I know the experts have already spoken on deposition witnesses. If you have a bad case and you have a large corporate client who's the defendant, large landowner, a bank, you represent some banks on personal injury cases, whenever I walk into a jury room in a case like that, I kind of make a joke about, hey, I represent a bank. Do you think this case is worth X number of dollars? Just because we represent a bank? And then I try to get people, you have to sort of like begin to convey to the jury, and this will start with, from the beginning of the case, that the bank is made up of people. And the accident was a result of maybe the janitor at the bank not doing something he should or should not have done. And it's his conduct at issue in the case. It's the little guy who works for you, and you're going to hear from them. And this goes back to prepping your witnesses. When you have an unsophisticated witness, as perhaps a key witness in a case, you really need to spend time working with he or she. I don't know how many times I've seen, maintenance people or people who are at the kind of the front lines of any organization. They're called as a witness. They're like a deer in the headlights, and they immediately fall on their sword, and they collapse when they're challenged about, their inability, or they didn't act safely. They weren't concerned about people, and the plaintiff's attorney is able to lead them down that road. So you're right, Alyssa. You need to prep these witnesses really well. You also need to early on in the litigation, you need to start telling your client's story. And this is true at the trial as well. I don't know how many cases I've seen, and I'm sure if you look at a lot of these nuclear verdicts, it's because, as you know, Steve and Alyssa have said, the key witness in the case came across terribly. Well, first off, you need a witness. So early on in the litigation, you need to confirm that someone is going to be involved in this case from the beginning to end who works for your client. You need to get them engaged early on in the case so they have skin in the game. You know, I always tell the corporate witnesses, plaintiff's attorney is going to try to paint this terrible picture. And you know that's not true, right? So you need to help me present your story, your version of what happened, why you did what you did, and who would be the best person to be the face of the company. And you better make sure you have that person in court with you every day or virtually these days. If you're doing a virtual trial, which I think I'm going to be starting one next month, should be an interesting experience. But you need to establish credibility early on. You need to tell a story. You need to humanize your client. You need to tell the jury that this case is really about the little guy who works for you. It's not about, you know, the guy working in the C-suite. You need to kind of flip the tables. You also need to, and I'm sorry if I'm going on, but you know, this is a passion of mine. You also need to you need to resensitize jurors. You know, as several people have mentioned already, jurors are used to hearing huge numbers thrown around all the time. Until about 10 years ago, whenever a plaintiff's lawyer stood up and said, you know, I'm going to be seeking a lot of money, I used to see like eyes roll, you know, in jurors, and they couldn't wait to tell the plaintiff's attorney, you know, I don't believe in these cases. I bet you're going to ask for $1 million. I can never give $1 million. Now, when I see plaintiff's lawyers say this in front of jurors, they're all kind of like nodding their head, like this is normal. Like every case is worth lots of money. And a lot of that is fed by, you know, the advertising. Celino, I don't know if anyone's aware of the firm Celino and Barnes, which was in New York. I think they may have been in a few other states. They started an ad campaign about 5-6 years ago. It was brilliant. They had professional actors go on camera and tell in their advertisement for their firm, I was in a motorcycle accident. Now you're looking at this person, there's not a scratch, they look perfect. They look like a movie star. And I got $5 million for my case. The insurance company, that was 25 times what the insurance company offered me. So they're telegraphing insurance. This is only about insurance, and that every case is worth millions of dollars. So you got to confront that. And I confront it, and I recommend lawyers do that in jury selection. Confront it head on. Question jurors about their feelings in that regard. What do they think? And bring out a discussion of it so you could kind of smack it down, and then bring in, you know, the facts that may have a chilling effect on a damage award to get a juror to admit, well, if you show me that, then yeah, I would agree with you.
Yeah. Okay. So, thanks, Alan. You obviously are very passionate about that.
Sorry about taking
Alyssa, do you go along with that? And if so, or not, what are some important things that insurers can do to avoid nuclear verdicts?
I was about to say that Alan just stole some of my thunder.
I'm sorry about that.
I completely agree with a lot of what he said. So just very briefly, some of the things that stand out in my mind would be, number one, properly preparing your witnesses, regardless if it's for deposition or trial testimony. That's two very different types of testimony, and they need to be properly prepared. The second thing is figuring out those weaknesses and holes in your case and doing all of this, as Alan said, very early on. I can't tell you how many times that we have done a mock trial literally right before trial, and things that the trial team thought were important were completely innocuous to jurors and vice versa. There have been other times where we have clients say, if I had known this, I would have worked this case up completely differently from the very beginning, and so on. So know everything early on, get your answers early on. And then finally, be prepared to go to trial. I think oftentimes this is not necessarily the approach. And so if you're prepared to go to trial from the beginning, then one, you're working things up early. You're potentially scaring the plaintiff's bar some. You're giving yourself more leverage, and so on. I I think sometimes when you're a client who's paying out a lot of nuclear settlements, you become the target for future litigation. So plan otherwise as you move forward.
Steve, what are your thoughts? Did Alyssa and Alan steal all your thunder? Or how can the insurance defense industry combat aggressive plaintiff bar tactics?
Oh yeah, they definitely hit the nail on the head. A lot of things that I was going to say. I think one other thing that I'll just add on to that, is even though it may sound like Marie and I disagree with the whole idea of third-party litigation, I'm actually definitely in agreement that it's an issue and that it's something that needs to be addressed. I think one of the ways that I was thinking and talking about it is that the defense bar and their clients just need to be ready to take things to trial. That's one of the ways you can thwart this is let the plaintiff bar have their third-party litigation, let them do that. But at the same time, let the defense bar send a message that says, you know what, this corporation, this organization is not a cash machine that you can just sue and we're going to settle cases. We're ready to take this to trial, and we might take our lumps on some instances, but at the same time, we might get a defense verdict. And I think what you're doing then is setting the stage so that, amongst the plaintiff's bar, I'm sure they know that there's some organizations that will just kind of settle cases. And then there's organizations that they know that they'll have to take it to trial. So you want to be part of that and set the stage for the plaintiff's bar to know that when they're coming at you with a litigation, with a lawsuit, that they better pack their lunch because you're ready to take the thing to trial. You're ready to work up the case properly, and you're ready to do the things that they expect the defense bar not to do. As I can think of a case right now off the top of my head where it started as 4 lawsuits, then it went to 14, then it went to 24, because a lot of plaintiffs just started seeing that, there's an opportunity here to make some money. So then they just start layering on to try to get additional settlements and get additional money. So as I said, start early intervention and just be ready to take the thing to trial. And hopefully, like you said, you'll send a message to the plaintiff's bar that organization is not one to be tried.
Thanks, Steve. What a great discussion. Unfortunately, we have just about come to the end of our presentation today. And I'd just like to go around the panel and get everyone's closing thoughts and what they think the big takeaway is here today. And Marie Castronuovo, why don't we start with you? What's the big takeaway here today?
So I think the big takeaway is preparation, right? So for defense attorneys, for insurers, large corporations that are being sued, the important thing is to get in front of it. The case comes in, get your witnesses lined up, get your discovery documents lined up. With respect to litigation funding, we're not in the dark here. These guys have to file a lien with the UCC lien with the New York State Department of State. I'm sure they have to do that in other states. Those documents are online. They're easy to get. That document will give you the name of the plaintiff, the name of the funding company, and maybe even the amount, at the subject amount that was loaned. I would also suggest that you subpoena records from the litigation company, from other people, anybody that might have something to add to the case. But definitely, you can subpoena documents from the litigation company, the funding company. None of those documents are privileged, even though they may be email communications with the attorney. But between the funding company and the attorney, that's not privileged information. There'll be emails between the funding company and the plaintiff. You could get the contract. Perhaps you could find out what other cases this funding company has worked with this particular plaintiff's attorney on. All those things would be helpful to defending your case.
Thanks, Marie. Steve Wood, what do you want people to remember today?
On top of all the things we talked about and Marie just touched on, I think one of the big take-home messages for me is just for the defense bar to start communicating more. Plaintiff bar does a great job talking to one another, sharing tips and tricks and showing the things that worked and didn't work and teaching one another on how to be better attorneys. I think the defense bar needs to start doing that too, communicating and making sure that message gets passed along and they're doing the things that they need to do, sharing amongst themselves so that they can thwart plaintiff bar.
Thanks, Steve. Alan Russo, your thoughts. What should everyone know?
Very, very briefly, the big takeaway should be for the insurance industry. You need to invest money. You got to be not penny wise, and pound foolish, but invest wisely in defending cases early on. And that also means, and this is, I guess, a pitch for firms like mine, it's worth spending the money. That would be my big takeaway to prevent a bad result. And the only other thing I would say is and I agree with Steve, there's very little coordination among defense attorneys on tactics. It's beginning to change, but it's nowhere near where the plaintiff's bar is at. And advertising, messaging. I mean, the plaintiff's bar is constantly messaging about this area of practice and about damages awards in their advertising for clients. You know, the insurance industry is doing nothing. And your average consumer, that's what they're hearing. So I would say advertise, lobby, and try to influence.
Thanks, Alan. Dr. Alyssa Parker, you get the last word today.
Completely agree with what everyone before me has said. And I'll just wrap it up by saying it's essential to be proactive and preventative instead of reactionary.
Thank you, Alyssa. And thank you, panelists, one and all, for an outstanding presentation here today. We'd just like to remind everyone that AM Best is proud to be a premier sponsor of DRI's 2022 Insurance Coverage and Claims Institute Seminar. For AM Best TV, I'm John Weber.